Hello, I'm LA Controller Ron Galprin. As our city's Chief Financial Officer and watchdog, it's my job to manage the city's spending and to make sure that public dollars are being put to good use by keeping our government honest, responsive, and accountable. Because people want to know and deserve to know that our government is doing its best to serve you and to use your money well. It's important for the city to plan how to use its money wisely and make good investments. And it's just as important for each of us as Angelinos to do the same. Because the financial health of our city government depends on the financial health of every Angelino. That is why it's so important that we have programs and workshops for financial planning and financial literacy to help you to succeed and to make positive financial choices about your futures, to plan, to save, to invest, to manage your finances for your future, for your family's future, for our city's future. Thank you so much to our wonderful LA Library and its leadership, including Chief Librarian John Szabo. Thank you to all of the staff and to the volunteers, notably our certified financial planners, and the Library Department of Lifelong Learning and its partners. Thank you for ensuring that everyone has the tools and resources necessary to get on a good track and to stay on a good track financially. To help with this, I would encourage you to check out my How to Build a Financial First Aid Kit tool, which gives you all of the info you need to be prepared for an emergency. And you can check that out at lacontroller.org/financial first aid kit. I wish you a positive and fruitful experience at this event, and thank you all for participating.
Thank you, Mr. Galpern. Hello, everyone. I'm Caroline Zaccarni and work here at the Office of Civics and Community Services here at the Los Angeles Public Library. Welcome to Financial Planning Week. Today's presentation is brought to you by the Financial Planning Association of Los Angeles and the Los Angeles Public Library. Thomas Bennett from the FPA will show why individuals need an estate plan and highlight some of the basic components of an estate plan. We will have a brief Q&A after the session, so please send us your questions throughout the program. Take it away, Thomas.
Good afternoon, everyone. My name is Thomas Bennett. I'm with the Financial Planning Association. I'm actually a member of the Northern California chapter, the Diablo chapter. I am a certified financial planner, a chartered life underwriter, and a certified retirement planning counselor. So a lot of what I do really revolves around helping my clients, not just with their investments, but definitely their estate planning. Next slide, please. Could we switch to the next slide? Okay, having a little technical difficulty there. There we go. Okay, I think it'll be up in a moment. Okay, so a lot of times people think about retirement planning, which is very important, and a major part of that is your estate planning. What is estate planning? A lot of folks say, well, I don't have a lot of money. Maybe I don't have a family or children. I don't have a trust. Estate planning is really planning for your future, not just when you're gone and who's going to get your worldly goods and how you want them to get them, but it also can be part of while you're still alive as you get older in life. Some of the documents that are used in estate planning are particularly valuable. As you get older, you might become widowed. You might start to have issues with capacity. Estate planning documents can help you to move forward in your life in the manner that you want. Thank you. Key elements of estate planning are legal documents. Number one, estate planning is also, as I mentioned, one of the key concepts used in the financial planning sphere. So financial planning includes a lot of different elements: goal setting, budgeting, tax planning, estate planning, as mentioned, investment planning, also insurance planning or risk management. Estate planning is one of the key cornerstones of the financial planning process. Basic estate planning tools. Next slide, please. Before we start, one of the questions is, have you ignored planning for your retirement? And estate planning is part of that. So part of planning for your retirement is taking advantage of special accounts, perhaps through your jobs. You might have a 401k, a 403b if you work maybe for a nonprofit or a hospital municipality. You might have a 457 if you're a government employee. Also, if you're self-employed, there's a variety of different types of retirement accounts that are specifically designed for your retirement. IRAs, Roth IRAs. If you're self-employed, you might be looking at a SEP IRA or possibly a solo 401k. Having your estate plan include some of these accounts is definitely important. And, you know, a lot of us have procrastinated with a lot of things in life, and you know, there's no time like the present to get started, because when it comes to retirement planning, time is your friend. The sooner you start, the better off it will turn out at the end. Next slide, please. So here's a quiz. According to caring.com, what percentage of adult Americans have a will or a living trust? So everyone kind of ponder upon that for a few moments and place your bets. Okay. Next slide, please. As it turns out, only 32% of adult Americans, that's folks defined as 18 or older, have some sort of financial plan. Another way to think about this is that 68% of us have no plan. You know, one of the things I like to say to my clients is, if you don't have a plan, you do have a plan. It's actually established by the state, and we all live in California, I assume. The state of California probate law is your retirement plan, which means they're making the decisions, not you. Next slide, please. So here's some reasons that folks normally don't think about having a retirement plan. You know, and I have a lot of clients like this myself. They say, well, Tom, we don't really own a house. We rent. We don't have any kids. We don't have any money. We don't have an estate. And what is an estate? An estate is the sum total of all your stuff. Real property, cars, jewelry, baseball card collections, bank accounts, real estate, you know, your home or maybe rental properties, your retirement accounts for your job. All of this actually equals your estate. Another reason people don't, you know, move forward with setting up some kind of estate planning is there's family issues, which could be a whole lot of issues. You know, you might have a few kids and you want to be fair about it, but maybe one of the kids has a problem. You know, there's jealousy issues. There might be addiction issues, personality challenges, a lot of reasons why families kind of have analysis paralysis and never proceed. There's also a lot of complexity. People think that, oh my gosh, if I get a will or a trust, it's going to be so complex, no one can figure it out. It's really not that bad. I have clients that have millions of dollars. I have clients that might just have a few $100,000. I think everyone needs some kind of estate plan, because not only does it make it easier for you while you're alive and have your intentions known when you're gone, but I think it really helps your heirs to know what you really wanted, and it actually alleviates a lot of stress and grief and less fights if you have a document that just says, this is what I want to happen. Another issue is people think about the cost. You know, at the most basic level, you can get, you know, living documents like, you know, financial power of attorney or medical power of attorney. You can potentially get these as a boilerplate or off-the-shelf documents from an office supply or off the internet. I do think they're important enough that sometimes you have to spend a few dollars, find an attorney or legal aid, and have it done by a professional. You know, and it's not a happy thing to think about dying. You know, as I get older every day, I like to tell my clients, unfortunately, we're all getting one step closer to the end, and it's not a happy thing. So people kind of avoid it and figure, well, if I don't do my will or trust, then the Grim Reaper isn't going to get me. But, you know, driving in California, it could be any day, the way people drive on the highways sometimes. So I find that when folks actually get their estate documents in order, they have a sense of relief knowing that they can check the box. And if something does happen, their intentions are known. Next slide, please. So, as I mentioned earlier, what goes into your estate plan? You have your financial assets, which can be bank accounts, investment accounts, retirement accounts are mentioned there. You also have personal property. You might have a collection of jewelry that you inherited from grandma. You can have your home, inherited raw land, rental properties, and also insurance. And insurance plays a major portion of estate planning because it has some special benefits. Next document, please. So when you think about what are the benefits, what's in it for me, so to speak, if I were you, first of all, you're determining who gets what. Some people say, in my case, I have 2 kids. If something were to happen to me and my wife, it's pretty easy. We divide everything 50-50. In some families, you might say, well, if you have a few pieces of property, you might say, well, I want this child to get this property and this child to get cash or the other property. When you don't have a document, as I said, it's kind of settled by probate, and that might be what you want to happen, and it might not be what you want to happen. I also like to tell my clients that, as we get older and our kids get married, they might be in marriages that you don't feel confident are going to go the distance. So you might want to have that included in your estate planning documents where the assets are kind of isolated or protected from the potentiality of a divorce down the road. And also I always tell my clients that when you have children, inheritance is not a right, it's a gift. Sometimes I'll have conversations where they'll have 3 or 4 kids. I had a conversation with a woman yesterday where 3 of the kids really helped the parents and brought them to doctor's appointments and everything like that. And one of the kids that lived out of state really didn't have any interest whatsoever. And when the parents passed away, they left their estate divided by 3, not divided by 4. And the 4th heir was very unhappy because they didn't get anything, but their intentions were known. That's what the parents decided they wanted to do. Without having an estate planning document, that heir could have easily gone through the probate process and gotten, a quarter of the estate without any interest in helping the parents over the last 30 years. There's also the opportunity, which has tax advantages as well. You might have favored causes. It might be a church, a synagogue. It might be a temple. It might be your alma mater, your school, or the food bank. There's a lot of need for donations to food banks these days, or the Salvation Army, or the American Red Cross. There's a million great causes out there. And a lot of times people like to include a certain amount of money that goes to their favorite causes. I have a client where 2 sisters, one sister passed away, and not all but a good portion of her estate is going to her alma mater, which is her choice. She doesn't have any kids. She's widowed. She doesn't have anyone to leave her money to other than her sister and these charities. So she's really doing a good thing. And also, when you see minimalized probate, a couple things about probate. Number one, it costs money to go through probate. Usually for an estate, you're starting at 8%. So if you had a $1 million estate, that's $80,000 going down the drain for no good reason. So it can be quite expensive. Also, when your estate goes through probate, one of the things that a trust can do is it keeps your affairs private. If it goes through probate, it's actually public information, which means, you might leave money to, say, a child. It's now public information. It might be a sizable amount. And all of a sudden that child starts to get harassed by people trying to sell them stuff because they know, because it's public information, that, oh, you just inherited $1 million, or you just inherited an apartment building or something like that. And ultimately, a good estate plan, if designed well, can help to reduce taxes. As you get into much larger and more complex estates, there's a variety of tax planning strategies that's part of estate planning that you can do to help mitigate taxes, setting up special trusts, doing things with retirement accounts. I have a very wonderful client who happens to have a lot of money, but that's not why I like him so much. He's in his early 90s and he's very religious. And every year he actually takes his RMD, that's the required minimum distribution you need to take out of your retirement accounts, and it's 6 figures, and he gives it to his church directly. He's directing his money where he wants it to go. He's getting some nice tax advantages, which helps to reduce his taxes while he's alive. And he's actually seeing his donations at work while he's alive, not when he's gone. So it's really kind of a nice situation. Next slide, please. So what happens without planning? As I said before, the state, through probate law, determines who gets your stuff. And this can vary by state, but as an example, in my case, I'm married with 2 kids. If I had assets that were just in my name and I didn't have my wife's name on them, or I didn't have my wife as the primary beneficiary, if I didn't have a trust, the state of California might say, well, yes, you're married and you're the natural heir, but that account goes half to your wife and half to your 2 sons. Well, maybe that's what I want. Maybe that's not what I want. Maybe I want it all to go to my wife and my sons only get their share when my wife is gone. So not having some kind of document in force, or not having your assets titled properly, which is another part of estate planning. It's not just the documents, but also reviewing your accounts. There's things you can do. As an example, IRA accounts have a beneficiary. Oftentimes in my world, you might meet someone who's on a second marriage. Maybe they're widowed or they got divorced, and you review their accounts and find out that their deceased spouse or their ex-spouse is the primary beneficiary of their retirement accounts. And you hear about these things happening all the time, and you're like, oh my gosh, I died and I left everything to my ex-wife. What was I thinking? So reviewing retirement accounts is definitely part of estate planning. And also, if you don't have a trust, there's things you can do to title certain accounts. For instance, bank accounts. I work in a bank. You can set up an account, whether it's an individual or a joint account, transfer on death or pay on death to your children. And that way, that account does not go through probate. Your children go into the bank, say, mom died, dad died. Here's the death certificate. Here's our ID. We're on the account. And then the bank cuts a check to the children. That avoids probate. It's also pretty quick. And it doesn't have any tax ramifications if you're just talking about a bank account. When you talk about investment accounts, they can also be set up that way, but then the taxes can also get a little bit different. Probate can also be a long and expensive process, as I mentioned. I remember years ago having a woman whose husband died, and for some reason, all the money was in an account that she wasn't the beneficiary of, and she didn't have the money literally to pay her husband, and it had to go through probate. So she was borrowing money, taking out a loan from the bank to bury her husband, even though there was 6 figures in the bank, which was more than enough to bury her husband. But because it wasn't done right, it took a good month to go through the process. So some people can afford to do that. Some people can't afford to do that. And also, if you don't have your assets titled properly, the estate itself can potentially end up paying higher taxes. Certain accounts, as an example, retirement accounts, sometimes I'll have folks that might say, well, if I die, I want my IRA to go to my trust. Well, there's a few instances where that might be a good idea, but usually if you have a spouse or children, it's actually more advantageous to leave it to them in name, and then they can control to a degree the velocity that money comes out of the retirement account, which helps to mitigate the taxes. If you simply leave it to your estate, and pass away, all that money comes out directly, and it all gets taxed in one taxable year. So that can really reduce the size of the estate and what your heirs get. And ultimately, of course, family disputes may occur. Someone says, mom promised me the jewelry or the ring, or mom promised me this beach house, or dad promised me that, 1966 Mustang or something like that. Oftentimes, and you see it in the news all the time, where someone passes away, someone famous, a movie star, a rock star, and it's a big mess. I mean, famous examples, Prince, the singer, James Brown, the singer, passed away without actually having legal documents in place. And really, frankly, the only ones that make out are the lawyers haggling in court for 5, 10, 15 years trying to settle the estate. Not desirable. Next slide, please. This is the federal estate tax exemption. So if you look at this going back in time, you can see it's been increasing, which is great, but it's not permanent. So what this means is if you happen to be fortunate enough to have a very large estate, if you go back to 2011, what they're saying here is if you had an estate that was, let's say, less than $4 million, you basically have no estate tax due. You die, you leave your money to your heirs. They get a step up in basis, which means the cost of those investments that might have grown to $5 million is brought up to $5 million. And then your heirs can either, that's their new starting point, or they can sell it and not pay any tax. You'll see there was a big increase in 2017, and it's kind of adjusted with inflation. But you'll also notice the red bubble says that it is not permanent, meaning Congress, we all love Congress, they can go in there and they can lower it, they can increase it, they can do all kinds of crazy stuff. So, for larger estates, this is something to consider. Under the current tax code, if you said, well, here's an individual, a little bit less than 12 million, if they passed away and maybe owned a few apartment buildings, and let's say all in it was $10 million, you can leave that to your heirs and there's no estate tax due. The only accounts you'd have to worry about tax would be retirement accounts. So that's kind of nice, but it's kind of a moving target. Next slide, please. So like many things in financial planning, it's not an event, it's a process. Whether we're talking about developing an estate plan or an investment plan or talking about your goals, it really does take time to kind of reflect on, what the right answers are and what your answers are, not mine. So the first step is to set your goals. What are you really trying to achieve in your estate plan? Is it tax efficiency? Is it taking care of your children? Is it taking care of your spouse or a special needs brother or sister? Establishing what the goals are is really the first step. What are you really trying to accomplish? And as I said before, an inheritance is a gift. It's not a legal right. If you're married, that's one thing, but oftentimes I see children that aren't saving for retirement and they say, don't worry about it, Tom. Mom and dad are going to leave us $1 million. And I go, well, that's great. But you're one, you forgot to call your mom on her birthday, or you did something that bugged them and you're out of the will. So all of a sudden you don't have any inheritance. So it's not yours until it's yours. Evaluate your situation. What can you really afford to do? Some of my clients are well-to-do enough where they can give away a lot of money and they still have more money than they'll ever need, which is great. Good for them. Some of my clients, unfortunately, I see them helping out their children, giving them money to buy a house, paying for their grandchildren's education, and they're doing a lot of stuff, which is really nice to do, but they're depleting their estate and they're potentially not having enough funds to fund their own retirement, fund their own, if they have a long-term care event, which can be extremely expensive very fast. So really kind of appraising what is in your budget, and then having a plan. Once you've kind of figured out what you want to do, the goals, step one, what you can really afford to do, step two, then you really have to have a plan and say, okay, do I just need a will? Do I just need some ancillary legal documents, powers of attorney, that sort of thing? Do I want to go get a trust? And then how do I do that? Once you get those legal documents or the estate planning documents in force, you need to monitor them and adjust them. In my world, we usually say if you do have a trust, that's fantastic. But we usually recommend, even if there haven't been any life changes, new grandkids born or a beneficiary passing away, we usually recommend that you get your documents reviewed once every 5 years. But even more frequently, if all of a sudden, you're going to leave everything to your son and your daughter-in-law and they get divorced, you want to go in there and make those changes so that your ex-daughter-in-law doesn't get half your estate. I've seen documents that were written 20 years ago and they've never been updated. And I know things happen during a 20-year period, but also the state of California laws can change. trust documents are actually written and they're governed under state law. If you live in California and then you move to Texas, you definitely want to have a conversation with a lawyer in Texas to say, how does my California approved trust work in Texas? Is it acceptable, or do I need to rewrite it? In my own case, my parents got a trust when they moved from Massachusetts to Florida, but we had to get a special advice on, does the house in Massachusetts, how is that addressed under Massachusetts law by a trust written in the state of Florida? So that's definitely something to think about. Next slide, please. So setting goals. As I said before, you want to provide for your children, and you also want to think about the everyday needs of your spouse. Definitely in California, luckily, there's a variety of relationships. I would certainly say, from an advanced planning perspective, if you happen to have a same-sex relationship or marriage, living in California is one thing. If you move to another state, definitely you might find different rules. So if you're thinking about providing for your spouse that's recognized in California, but maybe you have a same-sex marriage, or you're just in a relationship and you move to a different state, you definitely want to review how's that going to work out. If, for instance, your spouse or significant others in the hospital, do you have visiting rights, things of that sort? Are they going to be entitled to inherit these assets, or are their heirs, meaning your heirs, going to come in and say, oh no, we have the legal right to it? When you think about setting financial security for the family, there's obviously providing for the children and the everyday needs, which means maybe not your child getting $100,000 BMW when they turn 16, but maybe getting a basic car to get them from here to school, that sort of thing. Thinking about the cost of education, are you thinking about a public education, or are you thinking about a private education? What's reasonable? And also, assuming you can take care, of course, your most immediate family, do you have the resources to share with relatives and friends? Oftentimes I'll have a situation where someone will leave maybe more than half to a family member that's been down on their luck or just not been as successful. Or they'll say, well, my sister really needs it. She got divorced. She doesn't have a job making a lot of money, but my brother's got some great job. He's making a ton of money and he really doesn't need it. So I'm going to leave, 75% to my sister and 25% to my brother, and really kind of selectively looking around and doing that. I just had an appointment last week with an older gentleman that just his friend died. I don't know his friend. I don't know, if he had family or not, but he left my client $200,000 of an investment account, which was mighty darn nice of him. But those are the sorts of things you can think about. And also, as I mentioned before, charities. There's tax planning advantages, but, a lot of folks aren't born with a silver spoon in their mouth, and maybe certain charities have really helped them when they were younger, or as they were growing, or maybe they got a scholarship from the alma mater, or maybe they had a very special relationship with their temple or their ashram or their church. And, they kind of really want to recognize that in their estate planning and give back. Next slide, please. So once again, taking inventory of your assets. So when you think about your net worth or your estate, as I said before, it's sort of the sum total of all your stuff. But really, when you start thinking about, well, am I going to be subject to estate tax? Really, your net worth is all your stuff minus what you owe on it. So you can have $1 million house, but if you have an $800,000 loan on it, your net worth is $200,000, because you're going to subtract whatever loans you have. If you have student loans, loans on homes, loans on cars, when you add up all your assets, you have to subtract the debt from it to kind of calculate what your net worth is. And that's important to know when you start thinking about, hey, am I subject to that estate tax that I heard about? And really kind of chronicling. I mean, I do it for myself. I just use a simple Excel spreadsheet. It's not fancy software. And I just start listing stuff and adding it up. And hey, what do I think it's worth? When I look at my house, I say, well, I'll just check maybe Zillow or some website. And it's not going to be 100% accurate, but it's going to get me in the neighborhood. And also, as I mentioned before, really reviewing, and I see this a lot of time in my practice. Just before I came here today, I saw a couple that's married, they got 3 kids, they got a house, they're very successful. And I was looking at one of the accounts that was just in the husband's name, not the husband and the wife, not pay on death to the wife, and that's fine. I just asked him about it. He's got every right to do that if that's what he wants to do. And he goes, "Oh, I forgot about that." He had opened this account before he got married like 15 years ago. And I said, well, it's very easily, you can just, transfer it into an account that's in both of your names. And if something ever happens to you, then your wife doesn't have to go through probate, and which is what he wants. Also, there's a variety of different ownerships, and doesn't matter if it's a bank account or a brokerage account. Joints with rights of survival. Most commonly, you'll see this with a husband and a wife. That means both own the account 100%. It's not a 50-50. They both have 100% access to the account, legal right to the account. And if something happens to one of the 2 spouses, meaning they pass away, the account automatically reverts to the surviving owner, which could be a spouse, or it could be 2 brothers or 2 sisters, 2 friends. And you can do the same thing with certain types of real estate as well. And when you add all this up, kind of evaluating what your current net worth is, it's kind of a cold thing to say, but it's sort of like your report card. If you see your net worth increasing as the years go by, you're probably doing something right. If you see your net worth decreasing as the years go by, you might be over leveraged, meaning your loans are overtaking your ability to grow your net worth. It's not very romantic, but it's a tool that we use to kind of say, here's your 3 choices, and whichever choice increases your net worth the most, that's probably the one we should be looking at. Next slide, please. So special situations. In the modern world, I see a whole rainbow of combinations of, children from prior marriages, children from wedlock, folks that are getting married. We have family friends married 3rd marriage, different kids from each marriage, kids from the current marriage. It can be quite complicated, and there's not really a right or a wrong to it. You see a variety of situations where people might say, well, this is the stuff that I accumulated before I met you, so that's going to go to my kids. Or maybe they say, hey, we're just going to divide everything fairly and keep it simple, which is a nice intention, but without having a legal document when mom and dad are gone. My experience is the more money that's involved, the bigger the bloodbath and fights. And I don't think any parent wants to have their kids fighting over money. So really, it's a blessing. It's a gift to kind of get this taken care of before you're gone, in my opinion. Also, special needs children. If you have a child that's on state aid, you're probably aware that if something happens to you and you leave a nice chunk of money to your child that's on state aid, it can actually eliminate their state aid. So this is when you want to talk to an attorney about getting a special needs trust, so that if something happens to you, the money goes into the special needs trust. It's for the benefit of your special needs child, who can also be an adult, but it does not disrupt their state financial aid, that the services, the financial aid, the benefits, the medical benefits that are being provided by the state. Also taking a look at business partnerships. Certain types of jobs, for instance, like a dentist, you need a special education to do that. And if you're the dentist and you pass away and you might be in a partnership with another dentist, and you leave your half ownership in the partnership to your spouse. The problem is your spouse might not be a dentist, but they're going to expect half of the income from the practice, but they're not actually doing anything because they're not a dentist. So this is when you want to look at having special legal documents, buy-sell agreements, which can be used with cash, where one partner agrees to automatically have their share sold to the other partner. It's usually funded through life insurance. I'm doing a deal right now for a gentleman that owns a construction company. And basically, if something happens to him, his net worth is really tied up in the value of the construction company. His wife is not. She has 5 kids. She's not going to go run a construction company. So we're using life insurance to say if something happens to him and the construction company shuts down, The life insurance will help to, provide for the family, for the wife and the 5 kids. And also, special collections and family heirlooms. When someone passes away and you inherit some antiques, what have you, some people are like, let's sell it. Let's go on the Antique Roadshow, right? We all see that and see what we can get. But there might be certain items. I know that when my grandmother passed away, it's not worth much, but it meant something to me. I wanted her pasta making machine. When my grandfather passed away, he had a little collection of German Steins, beer mugs, and they're worth a bit of money, but I'm never going to sell them because I don't look at them as an asset to be sold. I look at them as a family heirloom. When I look at it, it reminds me of them. So these are the types of things where you can say, rather than just liquidate everything and everything gets sold and you just divide it, you can use estate planning documents to really address these special situations. Next slide, please. So developing a plan, definitely start by consulting a financial professional, kind of looking at the big picture, evaluating what you have. There are legal requirements, as an example, when you have some kind of will or trust, obviously they have to be written in a specific way. They have to be signed, notarized, copies provided. You really want to kind of do it the right way. I'd also say that a trick that I share with a lot of my clients, because we don't write trusts in the bank, is that a lot of folks work for large companies where you have what they call a legal aid benefit. And, people look at that and say, hey, I'm not going to fight with my neighbor over a fence. I'm not going to get a DUI. Why do I need that legal aid benefit through my employer? And it usually costs like $10 a month. Well, most of them, and the 2 largest companies, one is Met, M-E-T, remember Snoopy? The other one is Hyatt, which is spelled just like the hotel, H-Y-A-T-T. Next time you're doing your employee benefit enrollment period, if you work for a good sized company, look around and see if they have that legal aid benefit. You sign up for it. Once it goes into force, maybe say January 1st, you go through the benefit book and you call up and say, hey, I want to get my trust documents put in order. And they give you a list of attorneys and you go in there and basically it costs you nothing. I used it. I even got trust for my sons and they're in their early 20s. Cost me nothing except $10 a month for a year. And then once I got all the documents I needed, I discontinued that election on my benefits book. So for $120, basically I got myself a trust and my wife and my sons. And on average, certainly in the Bay Area, I can't speak about LA, but a basic simple trust, you're probably talking $2,500 to $3,500 easily. Just getting a will is a little bit less, but if you can get something like that for $10 a month for a year, I think it's a great bargain. Next slide, please. So the basic tools of the trust that we've kind of touched upon are you have a will. A will is great when you're dead. That's how I describe it, because you're saying, if I die, I want so-and-so to get this, that, and the other thing, and you're enumerating your assets. But it really kind of only helps you when you die. To the left of that, you see a trust. I sort of describe a trust as a trust includes a will, which it does, but also includes some other things that a will generally wouldn't include, like the durable power of attorney or the living will for advanced directives. So what do those really mean? A durable power of attorney means I can give, as an example, if I ever took a trip to Canada or Mexico or something like that, I could give the durable power of attorney to one of my sons or both of them, and they can act as my attorney, even though they're not attorneys. They can go into the bank, present it to the bank and say, hey, we need to take out $5,000 because our dad forgot to pay his property tax bill and he won't be back for a month. That's what a good durable power of attorney means. They're acting as your attorney. And keep in mind, you can cancel it. Just like you can change the beneficiaries on your will or in your trust, you can cancel a power of attorney. Another example of when is a durable power of attorney, kind of when you see it the most often, is as people get older and they might be getting sick, they might be getting tired, they might start to lose their capacity. That's when the durable power of attorney, you see it most often, where they can go in and transact business legally for whoever, their parent, let's say, or whoever funded the trust. Below that, you also have the living will or advance directives. This is when, through a legal document, you're telling the world, just how far do you want the medical universe to go to keep you alive. Some people might say, whatever it takes, whatever it costs, keep me alive no matter what. I don't care if I'm in a coma for 30 years, just keep me alive. And that's their choice. Other folks might say, hey, if I'm in a coma, I don't want to live if I'm in a coma for more than 30 days, or if I'm failing and I need to be kept alive on a ventilator and a whole bunch of other stuff, I don't want to live like that. And that's a personal choice. It's not here to judge or say right or wrong. That's a personal choice. If you don't have these documents, I can definitely tell you, having a family member that's in the medical field, people in the medical world, God bless them, we need them, and they've been real heroes, certainly over the last 18 months, but they're hardwired to keep people alive no matter what. So the only way you can kind of say, hey, mom doesn't want to live this way, is through a durable, an advanced directive saying, hey, I don't want this. The other thing I would also share is that some, as an example, Kaiser up here in Northern California, some medical institutions have their own advanced directives, meaning they might give you some grief if you try to use something coming out of the trust. They may or may not recognize it. So my advice there would be, if you happen to be a client of Kaiser or United Healthcare or what have you, wherever you think, if you got sick or injured, wherever you think you're going to go, you might want to ask the questions when you're not in a car accident, but just say, hey, by the way, would you recognize this, or can I put this in my file? Or do you, like in Kaiser's case, have your own paperwork that Kaiser's going to recognize? And I found that out the hard way. So that's definitely something to check on. Next slide, please. So a will. What is a will? It's a legal written document. You get professional advice. State laws vary. So as I mentioned before, you could get a will in California. California is definitely more progressive in certain relationship situations than other states. So you definitely have to ask yourself whether it's same sex or opposite sex or just a partnership. Moving to a different state, that state's laws will apply. So you definitely want to review that and potentially update your will as needed. The other thing is, as I said before, having a list of heirs and bequests. In my experience, it's better to actually name the heirs, name your children, name the grandchildren or the favorite niece or what have you. Because I've seen situations where you say, okay, I want to leave, my estate equally to all my heirs. And all of a sudden there's these heirs that pop out of the woodwork that no one ever heard of. And they said, oh, I'm the illegitimate son or daughter of John or something like that. So one of the things you can do is say, look, if their name's not listed, they're not intended to get any kind of inheritance through the will or the trust. So definitely listing your children by name. A lot of times I also advise my clients that as grandchildren, if you don't want to just leave it to the first generation, but you also want to think about your grandchildren, you want to list their names as they come along. And unfortunately, if they pass away, I have a client that when I first met her, she had 5 kids and she was an elderly woman. And then she proceeded to tell me how 3 of her children had passed away, it's horrible to outlive your children. So she really only had 2 children left. And then we had a conversation about, well, do you want the share that the 3 children passed away, do you want that to go to their families or do you want it to go to your children? And, that was a good conversation to have. You also have something called a personal representative or executor or executrix. This is someone who is going to act for you. It's a little different when you have a trust because you actually have what they call a successor trustee. But if you just have a will, you're basically in the legal document, rather than going to the courts and requesting to be appointed the personal representative, you're actually saying, I want my best friend John or I want my daughter Sue to act as my personal representative or executor. And a big thing is if you have minor children, if you're a single parent or young parents and you pass away and your children are under the age of 18, I mean, this is a whole kettle of fish besides being very tragic. If you leave money directly to the children, whoever gets the children gets the money. I've think of a few situations where if the mother died, one family in Oakland where the mother was a single mom. She had, I believe it was 7 children from 5 different men, and she had a lot of life insurance. And I was like, hey, if you pass away and leave this money to the children, these guys, and a couple of them had drug problems, unfortunately, and some other challenges, they're going to show up to get the money. They're not going to show up for the kids. So you can identify a guardian. It might be a sibling, it might be a best friend, or someone you totally trust would never use the money for their own purposes, to really make sure the money's there to help raise the kids and is spent the way you want it to be spent. Some people might say, hey, I just want, if I die, I want my kid to have a basic, nice little car to drive around when they first come of driving age. Or the guardian might say, oh, no, that's not really what they want. They want to have a Porsche or something crazy like that, which might not be your wishes. So once again, appointing the right people and having the right legal document to basically tell the world what you want to happen is critical. Next page, please. What's not in a will? Jointly held property, because that means that 2 people own it. You don't own it exclusively by yourself. As I said before, tax advantage retirement accounts, by definition, have a beneficiary. So IRAs, Roth IRAs, SEP IRAs, 401ks, 403bs, 457 plans. If you think about when you first started a job, or if you've ever opened these accounts up, besides having your name, whoever helped you with it or whatever paperwork you're dealing with, they always say, who's your primary beneficiary? So you might say your spouse, then you have secondary beneficiaries. It might be the kids or someone else. Also, of course, insurance policies. Insurance policies have a beneficiary. So once again, they're not included in the will because they're actually what I call a tilted asset. If you die, if the insurance policy says that money goes to my mother, not my wife and kids, that's where the money's going to go. The wife or the husband doesn't have a legal right to it because the insurance policy, by definition, is a contract between you and the insurance company. And you're telling the insurance company, if I die, my mom gets this money. You didn't say my wife. So you definitely, once again, want to review all that good stuff. Property you no longer own. If you've sold it, if you've given it away, you really can't name it in the will because it's not yours anymore. If you transferred it to a trust, and there's many kinds of trusts, well, now we're getting to the next level, which is a trust, which is kind of its own little separate entity. It means you don't own it, the trust owns it, but you control the trust. Next page, please. As discussed, a living will or advance directive is basically saying a will is good when you're dead, but if you have a living will, it says this is kind of what I want while I'm alive. So it's sort of, I would place it between just a basic will and a trust. Having a living will really describes, what kind of services you want, how you want to be taken care of. Do you want to be put in assisted living or not put in assisted living? Would you prefer to pass away at home or in a hospital? All that fun stuff. And you definitely want to look at state laws because they do vary. Next page, please. Powers of attorney, as discussed. You can give a power of attorney away, and as it says, you can revoke it or change it at will. If you give the power of attorney to, say, your daughter, and you find out she's misusing it and taking advantage of you and stealing your money, you can revoke it and put someone else in there. Healthcare. Living will authorizes action of a life wish, may be revoked or changed. So you might say today, hey, if I get sick, I just, I want to be kept alive as long as possible. And then 10 years later, you might go, I've seen a few of my friends get old and they linger, and that's not for me. So if I get sick, I don't want to, have dialysis and be intubated and put on a respirator and all this other fun stuff. That's your choice. That's why having these documents matter. Next page, please. Trust. So once again, this is kind of moving up a little. It's, in my opinion, you need an attorney to do it. There's a bazillion different types of trusts. I think a good lawyer is going to ask you and spend the time to ask you what you really want to happen, if this happens or that happens, and ask you about your relationships with family members, as opposed to the attorney that just says, fill in the blanks, write me a check, and, kind of a boilerplate document. You'll know a good attorney when you bang into one, because they're going to really ask you the right types of questions, spend the time, and really educate you on what your options and choices are. Next slide, please. Gifts. There's different times you can give gifts. You can give money now, which helps you to reduce the size of your estate if you think you're going to be subject to an estate tax. Right now, anybody can give anybody $15,000 per year. And I like to, if you've got a married couple, mom and dad could each give $15,000 to each of their kids each and every year, assuming they can afford to do it. That helps to help their kids out now. It helps to reduce the size of the estate. And the nice thing about it is the kids don't have to say they got it, and you don't have to report that you gave it. You can give more than $15,000 a year. You could give, as an example, $100,000 a year to your child or someone else. It's not a taxable event, but it now becomes a reportable event, meaning you have to report that you gave more than 15, which is on 100,000, 85,000, and they have to report that they received 85,000. And all that really does is it reduces your lifetime exemption. In the United States, all gifts to a spouse are unlimited. You could give $1 million, $10 million, $100 million to your spouse. When you're married, there is no limit. And also, you can give gifts to schools or medical facilities to pay bills. That's also unlimited. So if you wanted to pay for your child's education, as an example, or a grandchild's education, they don't look at the $15,000 figure, because you're basically paying for that. Next slide, please. Taking action. This is the toughie. Choose the tools you're going to use. Decide on your heirs and your executors. Really picking the right people is critical. Trusting them. Knowing that you can change it if you need to. Sometimes they start out really good and then hit financial stress, and good people can do bad things, unfortunately, sometime. Get the documents done. I can't tell you how many clients have said, oh, do you have a trust? And they go, oh yeah, I have a trust. And I go, great. What's the date of the trust? And they go, well, what do you mean? I go, well, the date you signed it. And they go, well, we got it. We went to the attorney. We got it written up, but we never actually signed it and got it notarized, which means your trust actually has no value. It has to be signed, it has to be put in force, and it has to be notarized in order for it to be valid. Some of the other tools you can look at are buying insurance to help mitigate if your estate is so big, buying insurance to mitigate the estate tax, or buying insurance like long-term care insurance or life insurance to kind of manage some of the risks that you can run into as you get older, or while you're younger and you have a family, you might need life insurance for that as well. And then really communicate what your plans are to your family members. Doesn't mean you can't. I think it's good to let people know that you've got something, but that doesn't necessarily mean you have to tell them what you have in particular. But it is good to communicate. Next slide, please. Insurance. So some of the basic stuff we're most familiar with, homeowners insurance, renters insurance, automobile insurance, also liability insurance. If you hit someone with a car, you can easily lose everything if you get sued. So definitely having, the liability insurance and the automotive insurance are critical. When you think about financial security, life insurance is cheap. It's the one thing you never want to use. But gosh, I started out in the insurance business, and I remember one of these old agents saying, Tom, if you think the person needs $1 million and they say you only need $500,000, you say, look, I'll make a deal with you. Do the $1 million policy. And if you die, whatever your spouse doesn't need, they can give back to the insurance company, no questions asked. So that's obviously a joke. But when you think about, especially during your working years, your biggest asset, the romantic answer, if you're married, is your biggest asset is your spouse, of course. But in reality, your biggest financial asset is during your working years, it's your ability to make money and generate money. Like I said before, I saw a gentleman this morning at 7 a.m. We had an appointment. He's got a stay-at-home wife, wonderful woman, 5 very young kids, and he makes over $1 million a year, which is great. But if he dies, the whole house of cards fall apart. So definitely life insurance is part of my plan for him. And of course, if you're a business owner, you want to look at buyout or buy-sell agreements. Next slide, please. This I think really varies by situation and family. You want to talk with your heirs. You want to kind of let them know you have something in place. Whether you choose to tell them how much you have or who gets what, that's your own private business. Having a letter of instruction is good. You can say, if this happens to me, the trust is in the safe deposit box at so-and-so bank. That's a good thing to have as well. And if you do have, a trust and you have a trustee and successor trustees, really not just naming them. I've seen this in the bank where the bank gets appointed the successor trustee, which is the trustee after you're gone, and the bank doesn't even know about it. So we don't really, we kind of go, hey, what do you mean we're the trustee? We don't even know who this person is. So you kind of want to let the people that are your helpers when you're alive and old and ill, or when you're gone, like the successor trustee or the executor, you kind of want to let them know what you really want. Next slide, please. Letters of instruction, it's just a letter, clarifying where are the documents? Is it in the safe? Is it in the safe deposit box or the safe in the basement? Important contacts, family members, phone numbers, addresses. And like I said before, in these legal documents, really just positioning certain assets. A bank account is cash. There's nothing romantic about it. But your grandma's pasta machine, you might not want that sold at the yard sale. Next slide, please. And as I said before, situations change. People are born, people die, people get divorced, people offend you. So you can move them in and out of these documents as you see fit. And also your financial situation can change. One day you might just be an average family with an average net worth, and the next day the company you worked for IPO'd, and now you're worth $75 million. Guess what? Your situation just drastically changed, and that really warrants a big review of everything. Updates with legal changes, laws change, tax laws change. Just because you got a trust today, that doesn't mean it's going to be good 30 years from now. So your situation changes, but also the tax law and really the laws of the land, meaning the state of California, can change over time as well. So you want to make sure your documents are current. Next slide, please. Working with a financial planner. That's what we do with the Financial Planning Association. We're very holistic. We take the big picture. We're not really just zeroed in on any one topic. Your advice is personalized for you. It's not cookie cutter. Everyone gets the same advice. Every situation is different. I've never seen 2 families that are exactly the same. Financial planners might not write trusts or be estate planning attorneys, but they usually have a list of very reputable, good, tried attorneys that they can reference for you and direct you to them. And those folks can get the documents together and also legal updates. Next slide, please. Thank you for your time and attention. If you'd like more information, there's a lot of great resources out there. The plannersearch.org. You can type in your area code, what have you, and it'll give you a list of financial planners in your neighborhood. There's also a lot of great resources through the Financial Planning Association website, fpa.org, just free tools that you can download and take a look at. Next slide, please. Next slide, please. I think that's it. Thank you so very much. Any questions here?
Hello, thank you so much. I am looking to see. So there is a question, so I will just introduce myself. So my name is Madeline, and I also work in the Office of Civics and Community Services here at Los Angeles Public Library. And that was super informative, Tom. Thank you so much. And the question that I see in the chat someone has asked, so someone initially asked how much a will costs to create, and we provided an answer. I will read that to you from your colleague, who said, creating a full estate plan that includes a will and generally all of the power of attorney documents, a healthcare directive, and frequently a trust often starts around $1,200 to $1,500, depending on the estate attorney. Costs will increase if your situation is more complex. An average price is likely $1,500 to $2,000 for an estate plan. The standalone will be a lot less expensive, generally a few $100s, but it's important to get those power of attorney documents completed. So the question the same person asked, so you can't draft your own estate plan from a kit?
My response to that is you could. You could even write what they call a holographic will, the old will on a napkin. And I'm a pretty frugal guy, but I think, there's a time to spend money, and this is one of them. You can certainly download a will, handwrite a will, go to Office Depot and pick up like a boilerplate document, like a rental agreement, which I guess on some level is better than nothing. But I think that, you're talking about, your assets, your intentions. I would say that it's worth, and there's a spectrum, you can call attorneys and say, hey, I'm single, I got a house. What do you guys charge to do a basic estate plan? And you can call around and get some quotes. And I also think a great resource is just talk to your friends, because your friends are probably about the same age and going through the same life stages, and they're probably looking at this too. So sometimes the best referral might come from a friend that went and got something done, and you can ask them how happy they were with the attorney and what they cost.
Thanks. Another question that came up is that this is the same person who said that her mother doesn't speak English very well and owns her house. What kind of legal document do we need? A will, estate plan, or just a letter from her saying who gets what?
Well, I think that especially when English isn't their first language, that can get pretty mucky. I would say that she still needs the same legal documents, and certainly in the Los Angeles area, if not the San Francisco Bay Area, there's enough attorneys out there. I have a lot of clients that are Indian, and I'll talk to them and I'll say, I guarantee you can find an estate planning attorney that speaks Hindi and can explain things to you in the way you want, but you want to have the documents in English because that's the language of the land. But I think that just because English isn't their first language, I wouldn't scrimp on their wishes. Even if they don't own a home, they must have something, just a simple letter saying, hey, if I pass away, I want all my jewelry to go to this daughter and my car to go to my son, or something like that. Having something written is better than not having something written. Okay.
And that person had an additional question and asked if estate planners allow children to translate if they were unable to locate or work with an estate planner who is, speaking the language that they were in need of.
Okay. I would have two comments. So first, when you're talking about children translating, the first thing is you would want them to be at least the age of 18. Okay. The second thing is, I hate to say it, sometimes children are not what we call a disinterested party. So if it's my Spanish doesn't get me very far, my French doesn't get me very far, but if you start getting into some other languages where the attorney has no idea what you're saying and they're translating, you think what the attorney is saying, I would think it would be better to try to find a disinterested party, maybe a professional translator that does not benefit from whatever these documents say, might be my advice, just because you don't know what's being translated.
Sure, makes sense. Okay, let me see if there are any additional questions. No, and I think we are we're definitely over a little bit of time. So I think that we're at our point of conclusion. So just for a note for the audience, a few notes that this week's presentations are available to view on the Los Angeles Public Library's YouTube channel. And every year we conduct these events to support financial planning and financial literacy. So usually they occur in October and April. So that's something to keep in mind when you're looking at the library's calendar of what's happening. And additionally, I wanted to mention that tomorrow is Pro Bono Financial Planning Day. So we do have all the appointments are at this time booked, but there is a waiting list. So if you're interested in going on the waiting list, you can go to www.lapl.org /financial-planning, and you can schedule, input your information, and you can go onto the wait list. And if there's available time, we'll get in touch with you. There is one more question that came up. So sorry. It was actually a question that we thought of too that we didn't get to ask, but here we go. So from a patron. So if elder relatives have assets in a different state, do they have an estate plans in each state, but one will in California, the state they reside in?
My answer to that would be that their estate plan should be written in the estate they reside in. But you definitely want to make the attorney aware, hey, we got a house in Massachusetts, we got a cabin in Montana, and make sure that attorney reaches out to legal counsel in those states to make sure that the trust document or the legal documents you have will be recognized in those states. As I said, when my own parents moved from Massachusetts to Florida to retire, the trust document was written in Florida, but they still had a house in Massachusetts. So the Florida attorney spoke to one of his peers in Massachusetts and sent him the language which spoke about that particular asset. Because, as I said before, trust documents are governed at the state level, not the national level. So that would be my advice.
Okay, thank you. Looks like we have one last question. What if a parent has dementia, and I think they mean the will, and the will is in their home?
What if the parent?
I'm not, maybe they don't think, they don't know where the will is?
That's a toughie. I think the trick would be to find the will, or maybe ask, normally when an attorney draws up a will or a trust document, they retain a copy. And if the attorney retires, they basically take their book of business, if you will, and whatever attorney's buying their practice will have those documents. So if they can't find the will, maybe trying to figure out who the attorney was would be a good course of action. And that's also especially good to know if there's problems within the family.
Right.
Sometimes wills can be destroyed intentionally because someone was left out of the will, but saying that, hey, there's a copy of the will at the attorney, which is a valid signed will, can at least make the person's intentions happen.
Okay, so actually there's a little more clarification, which is now posted on the screen. There's no estate plan, but the parent has dementia.
Well, if the parent has dementia and they haven't established any estate plan yet, then the natural heirs, let's say the child, needs to go to the court and get appointed guardian. That would be step one, to make sure that, the bills are getting paid and things like that. And like I said, if there is no estate plan and the person really does have dementia, not just a little forgetful, we're all a little forgetful, but if they've definitely diagnosed as having dementia, it's kind of hard for them to express what they want because they're no longer deemed competent. Mm-hmm. With dementia and Alzheimer's and things of that sort. So then you're kind of in a rock and a hard place where you're kind of by default subject to the probate law of the state. But I think first step would definitely be going to the courts, get appointed guardians so that you can help your parent, let's say, handle their affairs.
Yeah, it's definitely a reminder to I know how complicated. I had a parent with dementia, so I understand the complications of that. And it's helpful when a parent or sees it coming and can plan ahead. And, not that you see all those things coming, but, we had the benefit of having an advanced healthcare directive, which was very helpful. So,
and I'll just share a quick personal my father's died, but before he died, he knew he was dying. And we also kind of knew my mother was starting to slip fast. Had a family meeting, got a trust done. The whole family was there, my siblings, their spouses, all the nieces and nephews. And subsequently, my father died, but my mother was going down so fast. 6 months later, and I used to be a notary, 6 months later, no one would have notarized her document because she was going down that fast. So especially when you start to suspect that they're starting to slip, you really want to get hopping on it.
Yeah, for sure. And on that note, we do also at the library have ongoing programming with Alzheimer's LA that is really helpful for people who have family members who are experiencing Alzheimer's or dementia. So just as a side note, for questions in that space, maybe you can get some other support and information that may be helpful to you. Okay, so I think that we're done. Don't see any other questions, and we are past our time. So before Facebook shuts us down, we'll conclude. But thank you so much for your expertise and your time. And we'll see you all Financial Planning Month next year. And if not, then tomorrow for a lot of people who have signed up for appointments. Thanks so much, everyone. Good night.
Thank you so much.